So I received a really great question the other day from a lady whose boss was essentially trying to change her job role during her contract. And it's a very difficult situation to be, as many people don't want to cause conflict with their boss. But it has inspired me to create this short video here for you today on when can your employer legally change the terms of your contract. Because this does happen in reality. Employers will often attempt to make shadow changes to your contract, such as changing your salary terms or your bonus or commission terms, or even the scope of your job role. So in just the next few minutes, I'm going to teach you when can your employer legally make changes to your contract, what terms can and cannot be changed, and as always, the best step-by-step procedure to take if your employer is not playing by the rules. I'll also be letting you in on a secret but very effective weapon available to you if negotiations with your boss aren't working at the end of the video. For anyone new to the channel, welcome. It's me, Cal, your personal travel size lawyer, here as always to break down the complex legal issues into simple and easy to understand advice. So let's dive right in. When can your employer make changes to your contract? Well, once your employment contract is signed by both parties, neither you nor your employer can just randomly change it without some form of agreement or legal justification. But, and there is a big but, there are situations where your employer might be able to make changes, sometimes even without your consent. So here are the 4 scenarios where it may be possible for your employer to amend your contract. Number 1, when there is a flexibility clause. Now, some contracts include what's called a flexibility or variation clause. This gives your employer the right to make changes to certain terms, like your working hours or your location. However, just because a flexibility clause exists in your contract, doesn't mean the employer has a free pass to change everything and anything. The changes have to be reasonable. If your employer tries to change something fundamental, like cutting your pay or changing your job location, that's likely to be considered unreasonable, even with a flexibility clause in your contract. So step 1, ascertain if there's such a clause. If there is not, then changing the terms may not be legal. And even if there is, those changes still have to be reasonable. Now, number 2 are changes implied by custom. Now, in some industries, certain changes may be considered normal practice. For example, in retail, it's common for working hours to fluctuate during busy periods like Christmas. If this is something that's long been accepted as part of the job, then it might be implied as a term of your contract, even if it's not written down. So you'll need to consider your job sector and if such changes are natural in the sector within which you work. In finance, for example, and accounting, it is reasonable to assume that contracted hours may change during the end of the financial accounting year when work is busiest. This is the custom of the business and may be acceptable as an implied change. Number 3 is when you've agreed to the change, pretty self-explanatory. Now, your employer can always make changes if you agree to them. Now, that doesn't mean they can pressure you into agreeing. This must be a genuine agreement, ideally with a written confirmation. So if you have in any way expressed agreement to those changes, then unfortunately, those changes may legally be made. And finally, number 4 is economic or business needs. Now, there may be times when your employer wants to make changes for business reasons like restructuring or responding to economic pressures. While they can't really force you to accept those changes, they may try to negotiate them with you, but that is up to you. If the business is struggling, for instance, your employer might propose a temporary salary reduction to avoid layoffs, and sometimes it may be for the best, so make sure to fully consider the impact of your decision. So now we know when an employer can make changes. Now we need to look at what changes can be made. Now, as we discussed before, your employer may be entitled to make changes, but they must be reasonable. And it's essential to know what is reasonable and what is unreasonable. So to do this, we'll look at the 5 most common changes, and those are salary changes, working hours, changes to your job role, changes to your bonuses and perks, and finally, changes to your job location. In reality, this can apply to any fundamental change that your employer is trying to make. So number 1, salary, one of the most sensitive areas. Your employer cannot just cut your salary without your consent. Even if there is an economic reason like a downturn, your employer must get your agreement first. If they reduce your pay without permission, you can potentially sue for unlawful deduction of wages, so know your rights. Number 2 is working hours. Your employer might try to change your working hours like I discussed before, like asking you to work evenings or weekends instead of your usual 9 to 5. But again, unless there is a flexibility clause in your contract like I mentioned before, or you agree to it, then this is not allowed. If your employer tries to force you into new working hours, you can challenge it. The same applies to overtime. If there is nothing in your contract about overtime, they cannot make that fundamental change without your permission. Now, number 3 is your job role, because employers can try to change your responsibilities or even your job title on your contract. Now, this can be a gray area if the change is minor, like adding a new duty that's closely related to your current role. It's often fine. But if your employer suddenly wants you to take on a completely different role without your consent and is trying to make that change in your contract, then that could be a breach of contract. If the role that they're trying to make you do is distinctively different from that of the job description that was advertised or that was in your contract, this can certainly be challenged. Now, next we'll look at changes to your bonuses and your perks. Now, employers cannot remove or reduce bonuses that are written into your contract. For example, if your contract states that you're entitled to a yearly bonus or certain benefits like a company car, they can't just take these away from you without your consent. And finally is your location of work. Now, employers may try to move you to a different location, especially if the business is relocating. If your contract includes a mobility clause, this may be allowed, but again, change must be reasonable. Moving you from London to Manchester, for example, without any additional compensation, probably not reasonable. But moving you to another office in the same location or making you come into the office occasionally if you are working from home may be considered reasonable, particularly if expenses are paid. All right, so now you know when changes can be made to your contract and also what changes are reasonable. Now let's look at if you are not happy with the changes being made, what can you do about it? And before we carry on, guys, just one quick thing. I haven't and won't at any point ask you to hit that subscribe button. Instead, I'd ask you only to give my channel a chance to earn it from you with my content. So if any of you at any point feel like you've learned anything of value from my videos, please feel free to do so. Thank you. So what to do if your employer tries to change your contract? So here is a step-by-step approach to handling the situation, including the secret weapon you have available to you as a last resort, which I'll come to at the end. Step 1 should be to review your contract. As I mentioned before, the first thing you must do is review your contract carefully. Look for the flexibility clauses, as I mentioned, that might allow an employer to make changes. Are there any terms about your hours, pay, or duties that the employer can legally alter? If not, you might be in a strong position to challenge those changes. Step 2, talk to your employer. Look, if you are concerned about the changes, it's always worthwhile having a polite conversation with your employer first. In some cases, the change may be negotiable, or your employer might be willing to offer something in return, like a bonus or reduced hours elsewhere. Now, employers often try to make these changes seem like they are mandatory, as they know many employers won't risk challenging them. But remember, it's better to resolve these things amicably before moving to any formal action. As for the formal action, it's step 3, put your objections in writing. Now, you'll want to formalize your objections in writing. This is important because it creates a record of your disagreement, which could help later on if the matter escalates. Now, it's at this point that if you're still not getting anywhere and you've raised a formal grievance and are not satisfied with the response, you may wish to seek legal advice. This doesn't have to be expensive, and many offer free legal consultations. Employment lawyers will help you understand your rights and your options, and they can guide you through the process of making a formal complaint or claim. Step 6 is the grievance procedure. Now, if negotiations fail, you can raise a formal grievance with your employer. It's a good way to show that you're serious about your objections. Follow the steps outlined in your employee handbook to do this, as it is a specific procedure. And finally, as a last resort, your secret weapon, and something that was designed for these specific circumstances, which is the constructive dismissal claim. Now, you can threaten a claim for constructive dismissal if your employer is still forcing a major change that fundamentally alters your contract and your job conditions. You might be able to resign and claim for constructive dismissal. Drastic, I know, but this is why I said it's a last resort. Constructive dismissal is designed for those who have been forced to quit their own job due to their employer's actions or inactions, such as making fundamental changes to your contract terms. If you win your case, then you can be entitled to significant monetary compensation for being forced to resign. This is a serious step, though, and you need to show and prove that your employer's actions were so unreasonable that they effectively made conditions so difficult that you were forced to resign. Definitely seek legal advice during this process, however. Okay, and that sums up the advice I can give you on this topic. Guys, as always, if you've liked or taken anything of value from this video that I've made for you, maybe drop me a quick like. Of course, subscribe to my channel to ensure that you have qualified legal advice in your back pocket at all times. Remember, although reliable, this advice does not qualify as legal advice. It is purely educational. That said, I'll see you in the next video.